Today on Law Weekly, Lagos State Judiciary visits Ikoyi prisons as part of activities to mark the 2016 legal year. The coordinator of the Lagos State Restorative Justice Steering Committee, Benson Iwagu, speaks to us on the spectrum of restorative justice as an optional pretrial diversion. And later, lawyers speak on the suspension of the former chairman of the House Committee on Appropriation, Abdulmumim Jubrin. Thank you for joining us. I'm Victoria Ido. Let's get to it. We start at the Ikoyi prisons, where the Chief Judge of Lagos State has released 20 awaiting trial inmates. She says this is part of a move to decongest the Nigerian prisons across the country.
The Chief Judge of Lagos State has released 20 awaiting trial inmates from the Ikoyi prisons. She says that this is part of the move to decongest the Nigerian prison across the country. 50-year-old Thompson Henry, who was a sector commander with the Nigerian military, has been remanded at the Ikoyi prison for almost 2 years. He tells Channels Television that he was arrested when he returned from duties in the northeast, accused of deserting the war on insurgency. Today, he and 19 others get their freedom. The Chief Judge of Lagos State, Justice Olufunmilayo Atilade, granted them their freedom. The Chief Judge says everyone deserves a second chance to live a normal life.
Without prejudice to any further proceedings that may be brought against you at a later date. And I enjoin you to go and sin no more.
At the Ikoyi prisons, there are 2,358 inmates. 221 are convicted, while 2,037 are awaiting trial.
It is my belief that at the end of the inspection, these inmates will be satisfied that justice has been dispensed to them accordingly.
It's an opportunity for the prisoners to showcase what would have been hidden.
Do it the second time. Okay. It is not reviewed.
Section 1, subsection 1 of the Criminal Justice Release from Custody Act, Special Provisions 2012, gives the Chief Judge of Lagos the statutory power to carry out this obligation.
Lawyers and judges in Lagos State have been brainstorming at the Bar and Bench Forum, focusing on issues troubling the judicial sector. The event held at the Lagos Island Division of Lagos State High Court Igboshere as marking the commencement of the 2016 legal year.
Gathered here are members of the Bar and the Bench for an interactive session marking the start of the Lagos State 2016 legal year. The Chief Judge of Lagos State, Justice Olufunmilayo Atilade, says she looks forward to a new year where the state justice delivery system would be enhanced. But for that to happen, more judges need to be appointed. On the table for discussion among the lawyers and judges is the issue of plea bargaining and negotiation in criminal justice administration.
The use of the concept has been condemned by some legal practitioners and scholars, while some others have endorsed it as a welcome development in the Nigerian criminal justice administration. This is because, like any other concept, it has its advantages and disadvantages. Some of the more notable arguments against and in favor of plea bargaining are as follows. Arguments against: discriminatory and may cause injustice. The victims or people affected by the crime and the general public may sometimes be angered by the concept of a plea bargain, especially if they feel the crime deserves to be punished with the full extent of the law.
The Bar and Bench Forum is an opportunity for the Lagos State Judiciary to show the amount of work that has been done to improve the Lagos State Archives and Property Litigation Registry.
Statistics show that about 2.5 million Lagos residents suffer from one form of mental illness or another. This is the reason for this gathering, where stakeholders are discussing what the law must do to protect mentally ill individuals in the state.
People with mental health issues suffer stigmatization in many parts of the world, and Nigeria is no different. But that trend is about to change, at least in Lagos State, as legal practitioners Judges and medical personnel discussed the way forward. A look at the mental health law shows that the current law in Nigeria allows any building to house an asylum, and it contains no requirements for treatment of civil lunatics.
The protection of the human rights of people with mental disorders is an obligation of the state in the spirit of solidarity, beneficence, non-maleficence, and justice.
A closer look at the legislation shows that Nigeria's mental health law is grossly inadequate and urgently needs a makeover.
Our law on mental health remains grossly inadequate, indeed hopeless to deal with the situation that obtains in Nigeria today, where, despite the estimate of the World Health Organization, WHO, that about 20% of Nigerians suffer mental illness, and this was much more before the current economic situation, the predominant number of persons with these illnesses are either oblivious of it, ignored, or stigmatized by society, or end up in the care of spiritual and medical quacks.
If discussions here are put into good use, the issues of stigmatization and abuse of mentally ill persons will be a thing of the past.
The issue of restorative justice, which focuses on how to repair the harm caused by crime, emphasizes accountability and making amends, is our focus on today's interview on Law Weekly. And our guest is the coordinator of the Lagos State Restorative Justice Steering Committee, Benson Iwagu.
The issues affecting the Nigerian prison service, or the prisons generally, are so fundamental that there are no cosmetic, superficial approaches that can solve the problem. There are several. The first issue is the prison was conceived as a retributive institution for those who breached the king's peace. But what we've had is that over the years, because of the influence of democracy and all that, there's been this superficial attempt to change the name. For instance, I think in 2009 or thereabout, there was a bill proposed by the Nigerian Prison Service to change it to Nigerian Prison Service and Correctional Systems. But you see, once the foundation is wrong, the conclusions, whatever you do thereon, will be wrong. So firstly, to get the Nigerian prison system to what it should be, we should begin from the jurisprudence of our criminal justice system, where crime will be seen not just as an offense against the state, but will be seen as an infraction of persons, relationships, and all that. When it is seen from that prison, then the concept begins to change. The institutions that back up to that the Criminal Justice Administration will also begin to change. So for us, one, the foundation is wrong. Secondly, and because the foundation is wrong, you discover that the institution of the prison is of secondary interest to the powers that be. And that is why it is one of the most poorly funded institutions or agency of government.
At the Ikoyi prison, we have over 2,000 awaiting trial inmates, and just about well above 200 inmates convicted. What do you think can really be done on the issue of awaiting trial inmates?
Until a system is adopted where not every case goes to the court and is processed through our established criminal justice system, nothing can happen. We must have an alternative system that looks at individual complaints and then is able to deal with it in a way that is consistent with the interest of society, peace, and stability.
There's been a controversy over the Administration of Criminal Justice Act, the ACJ, passed in May 2015, as regards the implementation. What do you have to say about that?
I think it will be too early to come to that conclusion that it has run to a hitch. I would rather say that we should patiently yet explore it. One good thing about the administration of Criminal Justice Act 2015 is that it's brought some measure of accountability to the issue of arrest. For instance, if you arrest somebody as a police officer, you must be able to show good cause. The magistrates have been given supervisory powers and all that. So it's a good introduction. Also, the Administration of Criminal Justice Act has made provisions for restorative justice, restorative outcomes. So as far as I'm concerned, I think it's a welcome development. It's a good platform for us to begin to aspire forward. But we can't at this point consign it to failure. I do not subscribe to that.
You said something about restorative justice. Tell us more about that.
Restorative justice is an inclusive system of resolving criminal complaints that takes into account the offender, the interest of the victim, and the interest of the society. Now, what we have presently is that once a person is charged to court and is convicted or possibly remanded, the victim is still lodging in the court. The offender is still in apprehension, because that you've gone to court does not mean you have settled with me as a result of my car or relative that you killed. So restorative justice is evolved through time, to begin to look at justice from a much wider perspective.
How different is restorative justice from plea bargaining?
Well, plea bargaining is an aspect, is a tool of restorative justice. You use plea bargaining when it comes to restorative conversations, just as you use sentencing, victim-offender mediation. These are all elements of restorative justice. So they are not too different, except that in using plea bargaining in restorative conversations, you have to explore the nature of the harm and the hurt that have been committed. We are not saying that every crime or infraction is amenable to restorative justice process. No.
Do you think this will increase or reduce the rate of crime in Nigeria?
We are very, very definite and certain. You see, the good thing about restorative justice is that when all the parties that have a stake are involved in the conversation, it's a conversation. So it will not in any way escalate crime. Rather, it will begin to send out a positive message. It will not in any way escalate. For instance, we've said one of the immediate advantages is that recidivism will be under focus. And once we are able to put a hold on recidivism, we are headed towards getting a reasonable level of security and safety in our society. Restorative justice does not make leeway. It rather promotes the common interest. Remember, from the days of the social contract, the reason we come together as a people is I submit part of my rights as an individual in return for protection, in return for belonging, and all the benefits that come with association. But where you have a situation where your opinion is not sought, you lose your property, you are hurt, you are assaulted, it becomes IPO versus state. You are at best a witness. It doesn't heal your hurt, neither does it help the offender.
Let's talk about the process of restorative justice. How would it work?
It's going to be a pre-trial diversion process. It also will work pre-charge. In other words, it can work at the police station level when the prosecutor or the IPO looks at it and thinks, okay, this is what can go this way, rather than charge the person to maybe a first offender, maybe a juvenile, rather than begin to expose the person to the hardship and harshness and the corrupting influence of possible trial and remand. You say, let it go this way. It can also go when the person is charged before the court. The court, looking at the particulars of the particular offense, can say, okay, rather than go through criminal trial, let's divert this to restorative justice. Just like you have the Citizens Mediation Center. The courts will be in a position when the protocol is fully developed to be able to know in appropriate cases that fall within the classification as contained in the protocol will be duly diverted to the Restorative Justice Center.
Coming up after the break, Lawyers comment on the issue of suspension of the former chairman of the House Committee on Appropriation. Stay with us.